Be ready. 5 seconds.
These appeals take exception to the judgment and order passed by the National Green Tribunal, Principal Bench, New Delhi. Stop. There is also a challenge to the order by which, the NGT rejected the review petition filed by the appellant for seeking review of the impugned judgment. Stop. A notification was issued by the Ministry of Environment and Forests in exercise of powers under the Environment Protection Act, 1986. Stop. The notification provided that the projects falling under categories A and B set out in the schedule to the notification will require prior environmental clearance from the concerned regulatory authority. Stop. The regulatory authorities for different projects have been named in the first EC notification. Stop. For the A category, the central government in the MOEF was named as the regulatory authority. Stop. For projects in the B category, the State Environment Impact Assessment Authority was named as the regulatory authority. Stop. Various procedural aspects regarding applying for a grant, its processing have been incorporated in the first notification. Stop. There were subsequent modifications to the first notification. Stop para. In the original application, subject matter of these appeals, the challenge before the NGT was to the notification which modified earlier notifications. Stop. Appendix 9 to the second notification provided for exempting certain cases from the requirement of obtaining EC. Stop. By the impugned notification, Appendix 9 was substituted. Stop. The impugned notification was challenged on several grounds before the NGT by filing the original application subject matter of these appeals. Stop. Apart from other grounds, it was contended that the impugned notification violated the directions issued by this court in the case of Deepak Kumar versus State of Haryana. Stop. Even the ground that the impugned notification was arbitrary and violative of Article 14 of the Constitution of India was invoked. Stop. We must note that in the original application, the specific challenge was only to item 6 of the impugned notification. Stop para. In paragraph 8 of the impugned order, which we have quoted earlier, the NGT observed that the blanket exemption needs to be hedged by appropriate safeguards, such as, the process of excavation and quantum. Stop. Therefore, in paragraph 9, a direction was issued to revisit the impugned notification in the light of the observations made in paragraph 8. Stop. Within the 3 months provided by the NGT to do so, no steps had been taken to revisit item 6 of the impugned notification. Stop. The ministry has filed an additional affidavit and reliance has been placed on the guidelines for sand mining. Stop para. We are not entertaining a challenge to item 7 of the impugned notification. Stop. As none of the respondents have challenged the impugned notification, they will have to implement the directions issued in terms of paragraph 9 of the impugned judgment regarding item 7. Stop. Thus, notwithstanding the specific directions issued in paragraph 8 read with paragraph 9 of the impugned judgment, no safeguards have been provided, such as laying down processes, the mode and the manner of excavation and quantum. Stop. Therefore, we have no hesitation in striking down item 6 of the substituted appendix 9 forming part of the impugned notification. Stop. Accordingly, we quash item 6 in the two notifications above. Stop. The appeals are, accordingly, partly allowed on above terms. Stop. There will be no order as to costs. Stop.